It's Lisa from Been There, Got Out. And today's guest has been on here before. He is full of energy. Of course, he's a fellow New Yorker like me. And his name is Dennis Vetrano. He's an attorney. Oh, there he is. And we are going for a persuasion when it comes to putting together a compelling court case. Yay.
Hey.
How you doing?
Yo.
So thank you so much, Dennis, for coming back on with me.
No problem.
First of all, I have to thank you because I don't know if you remember a few years ago, we talked about something and the advice you gave helped Chris recently win his modification as a pro se. So
Good.
thank you.
Great.
Yeah. So anyway, so today we're going to talk about the art of persuasion and how to get a judge or a custody evaluator to try to get you what you need and get you out of there.
Yep.
So before you introduce yourself, actually just introduce yourself and then we'll get right to it. Who are you?
Somebody just said they love my nails. I don't know. They must be talking about yours.
I've got checkerboard.
Definitely not talking about mine. I'm Dennis Vetrano. I'm a 25-year practicing family law litigation attorney, and I do a whole host of social media stuff.
Yes. And you have donkeys as pets.
Yes. Yep. Yeah. Mm-hmm.
Among other things. All right. And you haven't been playing soccer lately in business shoes, right?
No, I actually just played for the first time in a long time, and the great thing is my boy came out and played. So now he was excited because he's finally graduated to playing with the adults who can really play. But he's 9, so
nice.
Yeah. So, but it's a challenge for him. That's okay. He's ready.
Good. Okay, so let's start early on, and I'm thinking about the initial
T-shirt too.
Okay. You're looking. I'm not even looking at the comments. You're looking at the comments faster than I am.
Sorry. Go.
But no, that's fine. So I'm thinking about the initial consult.
Yeah.
We know that it's an opportunity for a client to choose an attorney, but at the same time, the attorney gets to choose if they want to keep that client. So it goes both ways. So let's say I'm going in and I want to persuade an attorney that I like to take me on as a client. Like, what kinds of things do you look for in a potential client versus, no, I'm not taking this person?
I mean, look, let's put it this way. If you look at the reviews for our office, you will be able to pick out the clients that I never should have taken because those are the negative reviews. They guys say all this nasty shit, and it's like, those are the clients I should have. And judges have always told me, look, Dennis, you got to know when. But I'm the guy that always felt like you got to give people a chance because sometimes at first blush, people are going to seem, out of sorts. They're going to seem super emotional. You know my famous saying. It's like, people who are going through a divorce or family law litigation are usually 3 personality degrees away from their normal baseline. And you as the lawyer have to account for that. You have to understand how stressful of a situation they're going through. So I tend to always want to give a client a shot, even if they seem like, not really so.
Dysregulated.
Yeah, well, good word. But yes.
How would I know that word?
Because I feel like my job is to help people. I think my bottom line, though, is I know how expensive lawyers are. So before you start paying me a lot of money, I want to be crystal clear. And it's funny because I don't do the hard sell. I had a consultation the other day, and I think I could tell from the client's face, they were like waiting for the hard sell. And I was like, no. I said, hopefully I was able to answer all of your questions. Like, if you feel like we're a good fit for you or we can help you, we're always here. Just call the office. There's a full team staff to take care of you. I said, but I want you to think about it. And especially the cases that are like close calls. Listen, custody and visitation is such a wide open area and it's so subjective, and judges will render decisions all over the effing map. Some make sense based on the facts and the law, and some just don't, and there's kind of nothing you can do about it. You just do the best you can. So for me, I want to make sure clients go in eyes wide open and understand before you pay me $5, $10, $15, $20, $50, $30, $100,000 that you're certain that that's what you want to do. I'm here to do the best job for you that I can, but, and lately, if something, I used to take those cases where you had only like a 15% chance of success because the client is like, and I would explain to them, I said, look, this is a tough case. This is an uphill battle. But sometimes you have cases where it's either you try or you don't. This is your last shot. And even though the chance is only 15%, you got to take a shot. You got to go for it. And in
Right.
those cases, as long as the client understands, fine.
Okay, so then it sounds like with you, you recognize, and I know from previous interviews, you are trained in domestic violence. So you're not like a lot of attorneys overall. So you understand trauma like we do too. We know a lot of times a client presents as talking really fast and they seem really hyper and all over the place, which can
Mm-hmm.
seem like mental illness, but we know a lot of times it's trauma. And once they calm
Right.
down a bit, then we can deal with them. All right. So like you mentioned, our audience is people dealing with especially these long drawn out custody battles, and they are really emotional. And one of the questions that we get asked all the time that I'm sure you get asked too is like, how do I know how to document properly? Like if I'm dealing with a custody thing, let's actually start with some of the mistakes
Right.
people make when they think I'm going to go win my custody battle, like, and they're off. Like, what do you see people do wrong when it comes to the notion I'm going to go win my custody battle?
With a lawyer or without?
With
And in what circumstances? Because they're
let's
all.
do both. Let's say with a lawyer. Let's say I'll go to pro se later.
I think you have to adjust your sights a little bit, because if your thought is win, that's just so broad and so wide open. You need to know exactly what you're seeking to accomplish, what a win is considered for you. I think that's the starting point. Really focus on what you're seeking to
So
accomplish. And
clear
then,
goals.
yeah. One of the first things we'll do is we'll ask and I think like too few lawyers do this. They'll have a conversation and say, oh, blah, 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 this and that, this, we're going to do that. Did you ever just ask the client like what they want? What do you want? What do you have in your mind as your goal?
Right.
It doesn't matter what the lawyer has in mind. It's not even relevant what the lawyer wants. It's only relevant what you want. So I think you need to clearly define your goals at the outset.
Mm-hmm.
Know and understand the legal standard in your particular locale and your jurisdiction, and then know what it takes from a legal standpoint to get there. So,
Okay.
And again, custody and visitation, substantial change in circumstances such that it's in the best interest of the child to change the order in the way you're seeking to change the order. What in the F does that mean? It means something different. That's the New York State standard if you're trying to change your custody and visitation order. That means something different to virtually every single judge you'll go before.
Right. Yeah.
I've had ones that I just walked out going, I mean, really? You didn't think that was enough? Like, and quite frankly, some judges they are notorious for like, I don't want to be bothered with these cases. I've got a huge docket. I want this case to go away. I don't think it's significant enough. And for them, and for them in their head, their standard's very high. But you just got to know that going in.
Right, right. So I think knowing that from what we have experienced and seen with our clients, most judges don't have time. So a lot of it is you need to be very, very prepared and laser focused on what it is you want. And you're right, Dennis. I think sometimes people are just like, I need the judge to understand. We say, what's your goal? I need the judge to understand. We're like, that's not a goal. Do you see
Right.
that a lot?
Right. Yeah. Or I need the judge to hear me. I mean, here's the thing about clients, or let's say litigants, they wholeheartedly believe in their case. I mean, to a fault. And you can tell them you have a weak situation, you're not going to get what you want. And they don't care. They are 100% convinced, I don't need mediation. I don't need to negotiate. When I walk in before that judge and I tell him what I believe, he or she is going to see it. They're going to feel it. They're going to rule in my favor. We're going to be done. We're going to be like jumping up and down in the parking lot an hour later, and we're going to be all set. It's so much more complex than that.
Right.
My view of the world with cases, I know we've talked before about like, what's your philosophy on a case? My philosophy, I think that's always led to me being, dare I say, more successful than the average lawyer in this area is you have to have a theory on your case. You have to know what's the story of this case? What is this case about? It can't be, well, they left the toys in the yard and, well, they yelled at the kids and like, well, they're not mentally connected with the kids. Well, the relatives, well, blah, 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 blah. It can't be all that. It's got to be like the spirit is this other parent has never been engaged. They don't want to be engaged. And they're really seeking to have X because of what? So, I've always said when I try cases, I'm trying to put 3, maybe 4 major points before the court. I love these lawyers are like, I've got 575 exhibits, and they're walking in with like big cases and trunks of files. The judges are never going to have the time. If you're the OJ trial or you're, I don't know, the Johnny Depp trial, yes. And it's televised and it's multi-million dollars in lawyers. And you might be able to put all that stuff before the judge, and to the extent that they are interested in it, for them to actually analyze each piece of evidence. But in your average garden variety litigation case, have a handful of things, strongest first, that you're going to argue. Put your evidence in on each point clearly and concisely to prove those points, focusing on things that are objective as much as possible. My neighbor Sally saw X. The police officer came to the house, and here's his report, and here were his observations. The psychologist did this evaluation, and it said A, B, and C. Don't say I, and I had a client just recently, actually. Well, I don't understand why, if I testified to X, my mom shouldn't come in and testify to the same exact thing. Your mom's going to think, the judge is going to think your mom is an extension of you. Give me something objective that would support the things that you have to say. So clear, concise idea of what you want to happen in your case, clearly define your goals, understand the legal standard and how the facts in your case will meet that standard and get you to that goal. And then when you go before that judge, be organized, have 4 or 5 major points you want to get to, have the evidence supporting each one of those points, focusing on objective things more than subjective as much as possible. And that's what carries the day. I think the cases, especially with pro se litigants, like you said.
Okay, let's talk about pro se. I was going to say quickly before you get into it, when you talk about coming in with objective facts, we often say I'm saying facts, like things that are objective. You don't want to draw conclusions for someone else, right? You don't want to say, this is how it is. You want to just present, this is the fact, and let them draw their own conclusions, right?
Right. So it's funny. In my criminal law class, I can remember my professor shared this story. This is first year law school, many years ago now. And he said, my first opportunity as a prosecutor, cross-examining a witness. He said, I'm cross-examining, and he said, I brought up a point that should have impeached the witness. And he said to the judge, he points to the witness, you, sir, have been impeached, like something along those lines. I mean, something like that. Mm-hmm. So I don't remember the specific circumstances, but the point that he made, we howled when we heard that story, right? That was one of his mistakes early on as a prosecutor. The point is, you don't want to tell the judge the conclusion that they're supposed to reach. You want to provide them the path. So again, here's where you are. Here's the things you need to prove, and here's where you want the judge to get to. Your job is to create the path for them to get there mentally, right? You want them to do yes, follow along and listen to what you're saying, and then get to the end point, right? But it's your job to create that path for them. You don't tell them the conclusion, you create the path. Now, obviously, you say, what are you asking for? Okay, I'm asking for XYZ modification, blah, blah, blah,
Yeah. Okay. So you had started saying before I interrupted you, and we know we're both New Yorkers, so we interrupt each other a lot.
That's okay.
But with pro se, like, what's the difference if I am pro se, meaning self-represented, also known as pro per? So I am without an attorney. Is there a difference between a pro se going into court and trying to persuade a judge versus, obviously, I know there is a difference. What's the difference that you see?
I mean, it is. I mean, lawyers, the main thing that makes lawyers is they're taught how to think like a lawyer. That's what law school does. So I think you don't really have that, in your repertoire, let's say. But, so I think a lot of times with, pro se litigants, like I said before, it's like they're going to all these different things I want to argue. But I want the judge to hear how, like, she had an affair, and like, there's blah, 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 blah. Now remember, in a trial, the judge only has so much time. Even just every court appearance, I tell clients, and presumably pro se litigants as well, think of it like this. If the court has 30 cases on that day, how much time do you think they have? Sometimes they have 30 cases on in the morning. Okay.
Mm-hmm.
Have that many cases on in a 2-hour span. How much time do you think that judge actually has to listen to and process the points you're going to make? And sometimes you're going in for the initial appearance on an emergency application, and you've got to make your arguments right there because they're going to issue a temporary order on the spot.
Yeah.
And you've maybe got 5 minutes if you're lucky. Maybe 5 minutes total, 2 minutes aside, 3 minutes aside. That's what you got.
We often say it's like you're paying $6 million for the 30-second Super Bowl commercial. So you better make it good.
Yes.
So you got to come up with your elevator pitch in the beginning. Have you heard of the term front loading?
Mm-hmm. Yep.
So in the beginning, and so my background, is as a high school English teacher and a writer. And so I taught a lot with the art of persuasive writing. And now, I was able to use it in all these years of court with the art of persuasive speaking, but sort of like letting a judge know at the very beginning, here's what I'm asking for. Here's why I'm entitled to it in one paragraph or less before you get going, just so everybody's on the same page and judge is like, okay, now I know what we're going to do, instead of just launching into all your stuff and doing the blah, 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 all over the place.
And the best thing you can do is leave stuff out.
Right. Just like a writer.
Because when you walk in, you're going to have a list of 50 things you want to argue. And the judge, you're lucky if they listen to 3. Right. Take your 3 strongest ones and hammer those clearly and concisely, without emotion, without getting off on tangents. And if you find then you have more time, or that's not convincing enough, and the judge is giving you more time, then argue the next most important things. Sometimes the first 3 that you think are most important, they don't care about.
Right.
Whereas like number 6 on the list, whoa, carries the day. So, but you just have to see that's the best you can do. But remember, don't try to, because if you try to go for the 50, they're not going to listen to any of it.
Right.
If you try to go for the 3 most important ones, they're really going to be able to analyze the arguments you're making.
Right. And that's why I think it's so important, like you said, to understand the legal part of it, especially in a custody case. Like, look up your state's best interest. And if you don't have a lawyer, look up the best interest factor. We call it themes. So think about like 2 or 3 themes. I always think back to when I was teaching basic English to my low-level 10th graders of the hamburger essay. Intro, conclusion, 2 or 3 main points. That's the meat. Topic, sentence for each, and then a couple of details to get into it. It's the same. It's a similar kind of thing when you go, like, make your argument, make it really nicely, say what you're going to talk about, say why you deserve what you need, what you're asking for at the beginning and the end, and wind it up.
And guess what? Your phone is your friend. There's so much information out there at your fingertips. A lot of times you can simply Google, what are the latest trends in New York State custody and visitation law? A lot of times law firms do blogs on these things. So it'll bring you to a law firm's website where you can actually gain some legal knowledge and information. Or you'll see a video like something I put out or something else. So again, if you spend some time immersing yourself in that area, you can, pick up information. And the other thing I would say is, like, don't try to pretend you're a lawyer, because you're not. Once you say, well, judge, may it please the court, blah, blah, don't do that. You're not.
Don't say in the children's best interest.
The judge knows you're a pro se litigant. They understand that. And in fact, take advantage of that, because under the law, they're actually supposed to give you a little bit more leeway as a pro se litigant regarding rules of evidence, etc., when you're in there without a lawyer. So there is a principle there actually in the law. So I would take advantage of that, but I would also be non-emotional, organized, strongest points first, and have as much objective information as you can supporting your arguments.
Yeah, and the thing about not pretending to be a lawyer, one of the things that we also tell our clients is, which someone told us, is don't dress like a lawyer, like look nice, but wear more neutral colors. Don't come in with a dark suit and try to compete, because you just look foolish.
Yeah, and especially when there's a lawyer on the other side, you just like to, because believe me, when there's a lawyer on the other, you're not a good lawyer. You're not going to compete with a good lawyer on the other side. Even the smartest people I've ever met, and there have been some, even I used to defend prisoner litigation when I worked for the Attorney General's office, just before I graduated law school. And some of the prisoners actually with the law library there became relatively astute in the law, but they're still not lawyers. I would still see their paperwork and almost laugh. I mean, I'm not trying to be obnoxious. I'm just being honest.
Yeah.
So like when you're in there, take advantage of that Like, don't try to, well, I'm a lawyer and I'm going to make these legal arguments. Don't try to do that. I think try to focus, know the law, know what you need to prove, and put that information before the court. And then if the judge can give you some leeway as a pro se litigant, let them do it.
Yeah.
It'll help you.
Yeah. We teach a lot about courtroom demeanor and courtroom etiquette and knowing your place within the system. And I always think of it as the Wizard of Oz. The judge is the wizard, you're Dorothy. Don't come in there with guns blazing, like
Right.
this is how it's supposed to be, and you're wrong, and this is like, right?
Yep. And here's the problem for someone like me. Now, I've been practicing so long that now I'm getting to the point where if I go into court, I don't do a whole lot of court lately. I do a lot of managing and marketing and such. My litigation attorneys do most of that. But I'll go in, and if the judge does something wacky, I'll be like, it'll be tough for me to take because, like, judge, like, you know, I've been practicing a lot longer than you have. I know this area of law a lot better than you do. I've tried a lot more cases than you have. I know the rule of evidence better than you do, and yet you're going to tell me I'm wrong? Like, yeah. And that, listen, it's probably good for me that I don't spend as much time in the courtroom because I lose patience with judges who don't know the area of law, don't analyze the information like they should, don't know how to distinguish the cases that need the attention and the ones that don't. The ones that are the bullshit cases, and we all know what they are, don't be afraid to get rid of those cases. I need an order of protection because she threatened to go to court and file a petition. That's not a family offense. That's not a basis for an order of protection. Goodbye, we're dismissing your petition. You know, if you really feel like you're a victim of domestic violence, which is not apparent here, you can always go to the domestic violence hotline. You can always get support, you know, but if they don't have anything like that, those cases, because then the real victims that you know they're real victims, or there's a real situation there, you need to have the time to take on their cases. You need to say, if there's an important decision to make, okay, I know I've got 30 cases on today, but 10 of them that are garbage need to go. So that this one, or these 2 or 3 or 4 or 5, I can have a 20-minute mini hearing saying, I need to hear some testimony on this case because this is important and I need to rule on it today. I can't wait. Instead, you put them all in the same bag and you just keep adjourning them and kicking the can down the road.
I know.
But
I know. All right. So something you brought up that I thought, no, let me ask him about this, which I hadn't planned to, is emotional lawyers. I don't want to have, I know you rein yourself in, but
yeah.
I don't want to have an emotional lawyer because then things get distracted. How do I deal with opposing counsel, or how does my lawyer, if I have a lawyer, deal with emotional opposing counsel that's distracting from everything we're there to talk about and we're not having time to talk?
It's a tough situation because, so for example, let me distinguish emotional from passionate. You want a passionate lawyer. When you're doing litigation, you can't be like, you know, I'll give you an example. I've done litigation for years, and even with we very rarely need a lawyer. For one real estate dispute we had with a neighbor, we hired a white shoe law firm, top of the craft, you know, to handle that matter. But when we got into court, I was actually standing in as like co-counsel with him. When we got into court, like his talk was like this, and, you know, judge, this is what the law is. Very smart guy, very knowledgeable. One of the smartest guys I've ever actually met as a lawyer. But like, he didn't have that like edge. And sometimes that edge is what carries the day. So like, I stepped in for some of the arguments midstream.
I can imagine.
And then like the person on the other side started making scowls and this and that. So you'd be surprised if you're savvy about how you manage your passion for your case and your arguments and your inflection, how you can turn the tide on a case. But without really, you're not being emotional. You're using your passion to show how much you believe in the arguments that you have in your case. And sometimes you can use it in a way where you have somebody on the other side that's very easy to push their buttons. You just push the buttons, and then and then the judge, and then everything goes in your favor after that.
The pleasure of doing that. Yeah. But I was going to say, I think you probably are referring to if you don't have a lawyer, because if you have a lawyer and you start talking over your lawyer, that generally doesn't go well. We've had issues with clients. We have a number of lawyers that are our own clients, and it is very hard for them when they feel like their lawyer, because they've hired a lawyer knowing like, I can't deal with this, it's too emotional, but then their lawyer isn't doing a good job, that they kind of overstep a little and butt heads.
Or the lawyer's trying to save you from yourself. Sometimes I've had clients that just like, they're trying to like, I'm like, shut up, sit down and shut up. Right. Because like And listen, first you got to know the right lawyer. You'll see it, you'll feel it. First court appearance, you'll know. Give them a chance. Keep your mouth shut. If you have something to tell them, tug on their shoulder, whisper in their ear. Don't start. It's not like you're fighting with your lawyer and then they're trying to argue with the judge, and then the judge brain totally shuts off. So it's like, yeah. But definitely look. There's a difference between passion and emotion, and it's a matter of like controlling it and channeling it, you know?
Yeah. I'm still thinking like staying focused on the topic and not losing one's temper and going off.
Well,
Um,
and
what
listen,
about,
and keep in mind, savvy lawyers will target that. Once you do that, I know exactly who you are, and you will be my first witness I will call on my case, because I will do everything I can to push your buttons and just watch you.
yes.
I can remember a family offense trial I had many years ago. Call this guy, says, I didn't hit my daughter. I didn't. Now we knew that he did. So, we had pictures and everything. So I call him. I called him and just started putting his pushing. Didn't you do this? And didn't you do that? Like, he starts yelling on the stand. I was like,
I'm so glad you mentioned that, because yep. So that's one of the things also we train our clients to deal with. We just say the opposing counsel is going to bully you, plan for it.
Right.
They're going to try to get under your skin. And as soon as you get emotional, you lose it. But remember, that's a technique that a lawyer is doing on purpose to make you look bad. So I'm glad that you said it, as a neutral person just talking here, that you're basically a hired gun. You're an actor. You're trying to get the person to, again, lose their temper, blow up, or start crying, so you can say, see, this is how they are in the courtroom. Imagine what they're like outside the courtroom. They can't even keep it together. So it's so important to learn how to maintain yourself. We always tell our clients we want you to be calm, not by saying calm down, but helping you be focused and organized. And part of that is knowing what to expect. Expect the attack, because it's going to happen.
Yep.
So how do we stay composed?
All you do is you have to look at it like this. I'm testifying. You're not testifying. You're having a conversation with the lawyer in the presence of the judge. That's what you're doing. You're not testifying.
Right. And you look at the judge, right? If I'm on the witness stand, I'm not really, if you're cross-examining me, Dennis, I don't have to look at you. I can look at the judge, because I'm really talking to the judge, right?
And listen, there's also, make sure if you have a lawyer representing you, talk to your lawyer about it. Because first off, make sure you have the right lawyer, then they may have a strategy. What I'll try to do when I'm watching this is I'm not watching you as much as I'm watching the judge. Because what I'm trying to see is changes in the judge's facial expression based on the testimony that's being elicited.
Okay, talk about that a little bit, because I love talking about judges' body language.
The most important thing is the audience you're speaking to, and that's the judge in these cases. So, I remember a case I had years ago, and I was telling somebody this just recently. I actually read an email into my closing statement, because we're putting in evidence during the trial, and the judge is reviewing the evidence. Okay, noted for identification. Okay, is this the document? Yes, okay. Exhibit A, accepted. The judge has it. Judge reads it. Doesn't think much of it. Just reads it quick and puts it aside. Now, I knew that was my smoking gun. And I'm watching it. He just read it and just put it aside. And then our trial was not going very well. The lawyer on the other side was excellent trial attorney. Excellent trial attorney. Did very well cross-examining my client. So we get to the end, and I'm like, we're going to lose this trial. I don't see us winning this trial. I said, you know what? I said, I know I have the smoking gun. I have the email right here. And once it's in evidence, I can read it into my closing. I can do whatever I want with that document once it's in evidence. I can show it to you. You can read it. I can read it, anything. Once it's in evidence, take the document. And I said, it's very telling, blah, blah, small arguments. Sometimes, listen, a lot of times they discourage lawyers from doing openings and closings in family court cases. I don't necessarily believe in the opening, but I do believe in a closing. Because after the trial, you have to, listen, you have a vision of your case, and this is the way you want it to go. And here it is, right? And then after the trial, it went like this. But now you've got to pick out the high points that prove your case throughout the course of that trial. So in your closing, you have an opportunity, especially if you think the judge has not taken into account the important arguments that you think they should be taking a look at or considering, you have the opportunity to highlight those. So I took that email and I read it. And as I'm reading it, I'm watching his facial expression change. And I'm like, we're going to fucking win this trial. This email is going to win this fucking trial for us. It's going to do it. And if I hadn't read it into the closing at the end of the trial, because he glazed over it, we would have lost that trial. No question in my mind. Because I was watching
You
it.
won the trial.
What?
You won the trial.
Yeah.
Oh,
yep.
Great.
Yep.
That's awesome.
Cool.
So,
but
I was
those are
going
the
to
little
also
fine
ask,
points, right? Those are the little finer things. So, okay, you know, there's evidence, there's trial, it's a legal standard, but those little finer points, and that comes with having tried a lot of cases. So,
yeah, that I love that, and especially because I'm glad that you noted that a closing is more important than an opening.
yeah,
Than a long opening. Yeah, I feel like in my own experience, which of course, you know, and those of our clients, you have less time in the beginning. Things can go all over the place, but the judge will let you go through your closing.
yeah. Judge
Do you
doesn't
find that?
really want at the beginning. Judge wants to get started. Okay, you're not
Yeah,
settled. They're mostly focused on why you're not settled, and they're already aggravated. They have to try the case to begin with. So now you
right,
ask them to do an opening, they're going to be like, you know, most judges call your first witness. So
right.
I mean, you know,
Get
like,
on
but
with
judge, we were talking about settlement. We just needed a couple. Call your first witness. So,
yeah,
I mean, listen, I've had judges that I practiced before. Oh,
yeah.
so
We've gotten a couple questions about, is it better to be first on the stand or second? Or and I'm thinking first to file, or like the plaintiff or the defendant, like is one better than the other?
I mean, not necessarily. I think for you, the goal with the trial, as with anything else, is you want to start strong and end strong, right?
Mm-hmm.
So, in terms of how you put on your witnesses, um, you I sometimes I'll call the respondent first because I think like I want to take the wind out of their sails right out of the gate. If I know the respondent is going to be, difficult to deal with, or they have really useful information to put forth, and I'm confident I can control them, I would call the respondent first, meaning the person on the other side, meaning the other party.
Wow. Okay.
So,
Um,
remember in New York State, technically by their very nature, they're considered a hostile witness because they're the other party. Technically, many judges will say, "I've never heard of that." They're full of shit. That's what it is. If you tried cases, it's technically, I think it's called an adverse witness. So they're a witness who's the other party. If you're calling the other party, technically you should be. It's discretionary. Judge doesn't have to do it. But most judges who know how to try cases will. It's the other party. You can use leading questions. So, I do a mix, really. I mean, I don't really want to come in. Isn't it true that? Isn't it true that? Isn't it true that? Isn't it true that? Because you're building. When you
mhm.
ask questions in a trial, you're building what we call foundations. And you got to also think about how your transcript is going to read. So for me, I've had a lot of my cases when I started as a prosecutor, a young prosecutor. Almost every respondent's lawyer that lost wanted to appeal their case. So we actually had a lot of appeals. We didn't lose very many, but it taught me how your transcript's going to look on appeal. So, how is it going to read? Say, Sally Smith, didn't you go to the house on October, 22nd and, didn't so-and-so tell you blah, blah, blah. Okay, well, do you remember the date of October 21st? Yeah, what were you doing? And you went over to so-and-so's house. Yes, I did. And what did you plan on doing over there? We're going to do X or Y or Z. Okay, so you arrived at the house about what time? Blah, blah, blah. Okay, who was present when you got there? Oh, it was my daughter. Blah, blah, blah. Okay. And during that meeting, did you have a time to have a conversation with this other party? Yes, I did. Okay, so what did you talk about? Tell me what you said and what he said. So that second example is a foundation that will create a story so that on
It's
appeal,
short chunks. It's little bits
it's
rather than long questions.
details too.
Yes.
It's
Yeah.
break your when you're building foundations, you break your questions down. They can't be compounds, meaning asking two things at once. They can't be complex or difficult to understand. Short questions that build, that lay a foundation, meaning add detail. So what people don't realize is laying foundations, stronger foundations, actually lends to the credibility of any witness's testimony. So if I just ask, what did so-and-so tell you on Tuesday? It's very different than the way I let in the second time, right? Because now you have some context. Now you know other people were there. Now your memory of what did you tell me is, I know what time I went there, who was there, what was going on. Now your credibility seems much stronger, right? Because there's all those layers and all that detail there. So when I first started trying cases, I buried my face in a series of books called Proof of Facts, which are a set of books from the 60s that actually have form foundations in there. And it taught me how to lay foundations, how to certify experts, that's how I learned how to try cases. But mine are, sometimes the other lawyers would get mad. Oh, you're taking so much time. Okay. But if this case is appealed, your record's going to be like this and mine's going to be like this. Who do you think is going to win? You're not preparing just for the trial level when you're trying a case, ideally at least, especially if you think it's contentious or it's a close call. You're preparing for the possibility of an appeal, and that will live or die based on how strong that record is. So when you try that case, you're creating a record. That's the only record. They're not going to start adding stuff to it. That's what it is.
Right? You can't. You appealed, you can't add any new information.
Yep. And listen, it used to be where if we had a strong case, when I went into private practice, we had a strong case, we'd appeal it. And we were actually very successful on our appeals.
Really?
Lately, the appellate division's been so overwhelmed. They take so long to get a look at these cases. And I understand post-COVID. So it's not quite as, I don't think they have the time like they used to.
Yeah.
So.
Yeah. Oh, so helpful. Proof of facts.
Yeah.
We're going to start looking for that.
Proof of facts. I actually, you know what? So it was in the law library in Columbia County Courthouse when I was Columbia County Assistant County Attorney prosecuting child abuse and neglect. And I used to go to the library and look at that book. Now, after the fact, fast forward, I bought the set. So I have an old used set of Proof of Facts from the 60s. It's a really cool set of books.
That's great. I mean, a lot of what you're saying reminds me of just excellent communication skills and excellent writing. Like that's,
yeah.
So I'm glad I mean, this is really helpful. So you talked about hostile and adverse witnesses just because that's the term for the other side. But I'm thinking as a witness, because our clients are always on the stand and they're terrified. Are there things that they should keep in mind other than not letting someone get under their skin, trying to stay as calm as possible? Other things they should think about when they are being cross-examined?
I think the best thing you can do when being cross-examined is not try to outsmart the lawyer, because that's never going to get you anywhere.
Okay. What does that mean?
So like you need, when they ask you a question, answer it clearly, concisely, honestly, and be responsive to what they ask you. Like,
okay,
isn't it true that you walked across the street on that day?
What if,
don't say, well, yeah, but he yanked my arm and he shoved me across the street. Don't say that. Say, yeah, that's true.
So
just
short answer.
Just respond and only answer to what they're asking you. Because they have a way that they're going to build it, and either yourself on redirect or your lawyer on redirect will have an opportunity to clean up any inconsistencies that were developed through the cross-examination. So you don't want to try to do it midstream of the cross-examination, because then you're going to end up, kind of falling down a hole with it. And that's not something you want to do.
Okay, what if I'm being cross-examined on something and it makes me very uncomfortable and I want to not tell the truth about that because there's a longer answer and I'll look really bad? How do I handle that?
You got to be honest for what they're asking you.
Okay.
So be honest and answer the question clearly, concisely, and directly. And look,
Can you talk about
like this. Think of it like this. If you evade the question or try to be combative or try to outsmart the lawyer, you're going to look bad to the judge. If you answer their question clearly and concisely and directly, and then on redirect further explain that circumstance to clarify anything that you want to clarify on cross-examination, which you will have an opportunity to do, then the other lawyer looks bad. Then the judge is like, why did that lawyer ask that? That's just wrong. It's like, it's not helping you. That was stupid. I mean, that's what the judge is going to be thinking. But if you are combative on cross-examination, it's going to go the other way. So just, again, calm, clear, concise, listen to the question, pause for a minute or two, give your attorney an opportunity if they want to make an objection, and then respond. Just be honest.
Okay, so let's say, and this happens all the time, my ex is on the stand and they're lying, and I'm sitting and they're going, they're getting away with stuff. How could this be happening? What advice
Um,
do you have for someone who's has to sit there and listen to lies?
you got to keep your cool, man, because the judge is watching you. Remember,
Right.
as much as you should be watching the judge is watching you. So I always tell clients, look, when you go to the courtroom, when you go in the courtroom, especially in a trial, you're on stage. That's the
Yes.
way you have to look at it. It's like you're on stage, you're being watched. So,
So control your
right,
face.
just, as much as you can. And sometimes it's difficult, but like
It's really hard. It's really,
throwing, like, kicking chairs and no, just
I
like,
know.
be
But
cool.
even it's hard. Like I know early on I would just shake my head, and one time on Zoom a judge said, "Stop shaking your head." And I was like, "Oh."
Yep. Yep.
So now I look down or I look to the side, just sort of like I
Right.
just have to look at something else.
Right.
All right. What about outside of court? How important are negotiations and mediation outside of court? All of our clients are high conflict, they're dealing with domestic violence issues, and sometimes people say mediation is never going to work. I disagree, but I want to hear what you have to say about the idea of trying to settle or negotiate outside of litigation.
I think most of the cases I've had, and the longer I've practiced, the more I see this. Most of the cases I've had do better as a mediated settlement than they do as a litigated, final decision from a court. Because remember, you have no control then. You have no control. I always give the clients the example, hey, if you say, I want pick up and drop off to be, after baseball practice at 3 o'clock, and I want, this Sunday and that Saturday to be with me, judge doesn't have to follow that. Judge can do whatever the hell they want. And then you're going to be like, but wait a second, they set a schedule I can't even comply with. I work. Like, I can't get out at that time. Tough. It's court order for
Yep.
now. So what's your alternative? You're going to appeal that and the cost of that? So the point is, like, again, you got to know, and I think when you're putting together your goals for your case, be realistic. You have to, like, know the law, know the facts, and be realistic about what you're asking for. You know, if you have these situations and say, like, hey, I don't want dad to have any contact. Why? Well, he doesn't really feed the right dinners, and like he's late for baseball practice, and like, he doesn't really follow the rules and communicate with me like he should. Yeah, welcome to custody and visitation post divorce. That's probably about 75% of the cases. So the point is, you just got to know, like, if you're asking for, cut the other parent out, let's say, which is so extreme, keep in mind, when I was prosecuting child abuse and neglect, even neglectful parents are entitled to a minimum of like once every other week visitation with their kids. Parents who've been proven to have been neglectful of their kids. So now you got a parent that, like, again, neglect standard up here, you know, best interest here. Like, you don't need to prove as much to prove best interest as neglect. If you reach the standard of proving that this person cannot meet the minimum degree of care for a child, like, that's the minimum. And yet they still get, even though it's supervised, they still get, according to the regs, every other week visitation. Think about that. So
Right.
if you walk in and
It's like
say, well, he's not feeding the
planning.
right meals and you're not going to get that other parent cut out of the child's life. And quite frankly, you really shouldn't be wanting that.
Right. I saw a comment, and it's something we hear all the time, that said no judge should have that kind of power. What do you have to say
Yeah,
to that? I have a comment.
I think the best way to approach that is, the system is not perfect. It is a broken system. There's no question in my mind about it. And that's why I'm telling clients to really do their level best. I agree with you. I think mediation can work. I think even in very contentious cases, it can work if you add a couple of pieces to it, which I'll talk about in a
Right.
second. But if you think what you're going to get in family court when you walk through those doors is justice, and sometimes even fairness, you just don't get it.
Yeah.
Any judge, remember, any judge, you are dealing with their own experiences, their own prejudices, not prejudice in the classical sense, but in general, right? You're
Mhm.
dealing with what they value. I had
Right.
one judge years ago who had a military background. So relocating and having children move all over the place and travel for visitation, no problem to him. I had another judge who would say, you're not going to be able to relocate. You're moving 2 states away. I don't care. You've had a relationship with the children. There's no relocation here. You haven't met the legal standards. So again, one judge to the next can be totally different. So, and again, even things that should be important and should be relevant in family law in a particular case to a particular judge, sometimes they don't care.
Yeah. Yeah.
You know,
So you start talking about how mediation can work. Get into that, because that's one of my favorite topics too.
yeah, I think the best way to work with mediation in a contentious situation is to ensure that you have someone protecting your interests. So, for example, what I've been suggesting a lot lately is do the mediation. Like I got a client come in just the other day. Do the mediation. Give it a shot. If you think if you think there's a situation where you feel like it's not quite going like you expect, they're not speaking the type of language that they should be, it doesn't seem like you're getting something fair, or you want somebody to review your documents to make sure the agreement is done well, and or communicate with the mediator or the lawyer on the other side to make sure that the case is handled properly, or somebody to say, hey, you're not going to give up this, that's not fair under the law. You know, you just have a lawyer in the backdrop. You can each have lawyers and still work with a mediator. So, for example, I'll say, hey, you're not going to give up your entire interest in equity in the house just because. Or, you know what? You're not going to pay child support that's more than what the standard requires. You're just not going to do that. It's not what's fair under the law. However, then you can step in and say, hey, we're not going to have this in the agreement. But if it's something like, I gave an example with the client. I was like, okay, you call up your lawyer, no mediator, 2 lawyers. Call up your lawyer and say, okay, tell them 4:30 pickup is too late. I want it to be 4 o'clock. Okay, you call me, point 1, point 2, whatever it is. Now I call the other lawyer, point 1, point 2. She said 4 o'clock. Can you talk to your guy, see what he says? He calls his client, another point 1, point 2. Okay, 4:30 won't work. They want 4 o'clock. No, it's got to be 4:15. Now, how much money have you spent and time and aggravation over 15 minutes, something where if you were with a mediator, you could have worked it out like that. The two of you splitting the cost of one good mediator. But I will add this. I think there are mediators and then there are mediators. I think you need to have mediators who are very familiar with this area of law, not that they're lawyers necessarily, asterisk, necessarily, but most should be lawyers who know this area of law and they're immersed in it and have a good background. Because to be a divorce mediator in New York State, you don't need to be a lawyer and you don't need to know divorce law at all. Which still blows
if you don't, what do you think?
Still blows my mind.
What kinds of qualities do you think a good mediator should have with contentious cases? What are some qualities to look for in a mediator? Because sometimes it's court appointed, but a lot of times you have a choice for private mediation.
I think, look at what they're talking about. Because I've had some mediation agreements come across my desk where, I'll just give an example. I've had it on both sides. I've had women and men. Just give an example of like a guy came in and like, hey, I have this mediation agreement I agreed to, and I'm like, these numbers are just totally off. These shouldn't be paying. This is so much more than well, they told me I had to. You went to a mediator who sided with the other side and told you had to do something. That's called an advocate or a lawyer representing the other person. That is not a mediator. If they're talking like the language of like, hey, my job is to get you to an agreement. You two are going to drive this conversation, not me. Okay? But ideally, they should be in the middle. They shouldn't be advocating for you. They shouldn't be advocating for the other person. The key is to find something using the law as legal guideposts. Find something that's fair for both of you. That's the point. That's my view of what mediation is supposed to be. Is it going to be the maximum on one side and the minimum? No. It's never going to be that. It's going to be a compromise on both sides. And it's going to be a real view of what you have there. So maybe, spousal support numbers say X, but the needs of the children and the stay-at-home parent are different. Or with the tax implications, the payor doesn't have that kind of money. You've got to find something that works. And there's a lot of room. The playing field is big to find something that's fair in the middle, but it's got to be fair. You're going to have to compromise. But compromising is going to be a much better solution than leaving it up to a judge and having no control over it at all.
Yeah, we see so many situations where if a judge writes, let's say, a parenting plan or an order, people are constantly in court. In our community, because there's vague language and it never takes into the account the detail. So they're constantly spending so much money to go try to get clarification.
Yep. And I think of it like this. The other piece I'll add to it is, how likely do you think compliance is when you reach an agreement together versus when the court tells you this is what you're supposed to do?
Right. Right.
So
Well,
many
in our
clients
community,
afterwards, like,
compliance is
court
always
told
an
me,
issue.
fuck that, I'm not doing that. I don't give a shit what the court said. I get
Yeah.
that a lot.
Yeah.
But if the two of you say, hey, we reached an agreement, I'm not thrilled with it because it's not exactly what I wanted, but it's workable and I can live with it. And if both sides are saying that, it tends to be a fair resolution somewhere in the middle. And then when you've created that agreement together, you're much more likely, both of you, to comply with it. Because you had a stake in it. You had a part in creating the agreement. You didn't just have somebody telling you what you're going to do.
Yeah. I mean, we say to our clients too, if somebody gets in touch and they say my ex is going in for a modification, we say, well, when did you do the agreement? Oh, 2 months ago. Wait, you just did an agreement? Both of you agreed to something 2 months ago? Yeah, my ex is trying to change custody. And I'm like, I'm not a lawyer, I'm not a judge, but the fact that you agreed would make it stronger than a judge's order because you both willingly agreed.
Yeah.
And 2 months is barely any time for the ink to dry.
Yeah,
So
if I
why
remember
would a
correctly,
judge
it's
overturn that?
a little bit, I haven't researched this issue in a while. I think when you reach an agreement, the standard is slightly different for a mod in that it's got to be a substantial, unforeseen change of circumstances such that it's in the best interest of the children. You'd have to double check that with the law, but my recollection of the last research on that is when you reach an agreement together, the standard is even slightly higher to modify that.
Yeah, wow.
But that's a situation where, talk about front loading. I always believe in front loading my work. Right out of the gate, I start working on your case. I want to get it moving. I want to get everything organized, want to get everything ready to go. If I get a crap petition like that, I'm filing a motion to dismiss. Does it cost you a good chunk of money? Of course it does. But that is that is called best practices. That is best practices. You need to prepare well for your case in advance and right at the outset. Don't wait. There are a lot of lawyers, I think, and even litigants too. They don't do a damn thing with the case until 2 days before trial. There is no way you are going to, I'm talking about theories and like plans and like arguments and evidence and like certified records and like motions if you need to. And like that takes you months to put together. Start doing it before, be prepared in advance, and then front load your work.
Yeah. Well, Dennis, another hour has flown by as usual.
All right.
How can people find you? I know you're not doing as much with being in the courtroom yourself, but how can they find your firm?
Well, DRV Law is the Instagram and the TikTok handle. drvetranolaw.com, Facebook, website, stuff like that. So if you feel like you could use any assistance or advice, you could always reach out through the website. And we have a very good team here. That's part of what we built here. So, and check out the videos. I always think for people going through the process, it never hurts to just gather as much free information as you can, because that's your base, right? So.
Yep. I have a button that I love. It says, if you think education is expensive, try ignorance. So if you can get free education and people learn a lot, make sure it's the right information, but super, super helpful. So thanks again, Dennis, for all your energy and advice. And I've learned some things as usual, and I'm going to look up that proof of facts. So you can get a set.
Yeah, it's a good one. It's a good one. And it's funny because I told people, the first judge I used to practice before, he was like, hey, everybody should be writing their questions out every single trial all the time. Write them out. But when you've done a lot of them and you write your questions out over and over and over again, which I did, I got to a point where, okay, other lawyer would be like, okay, I want to try the case tomorrow. I said, tomorrow? Okay, let's try it right now. Let's try it right now. I have in my head how to lay foundations. I've done it hundreds of times before. You're ready for a trial? Let's go. Because my judge used to do that. He'd say, you want a trial? Okay, we'll try it Friday. Meanwhile, you're standing there on a Tuesday. Like, Judge, I got to get subpoenas out and call witnesses in. It's like, okay, how about Monday? But it forces you to be hyper organized and prepare well. And when you do that, it tends to carry the day. It was really good, a lot of good lessons I learned from him. He's actually running for family court judge in Albany now. So I'm very fond of him. He's a great lawyer, great judge for many, many years.
Wow. And that's where we both went to
Yep.
college.
Yep. Yep. Hopefully we'll see him back on the bench again. He was DA for a couple of terms, and he was family court and county court judge for a couple of terms. Now he's running again in Albany. So hopefully he'll win. He's one of the brightest legal minds I've ever encountered. So.
Wow, great. Well, thanks again for stressing the importance of preparation in all of this on top of everything else. And we'll talk to you soon, and happy summer.
Yeah, you too.
Okay.
Good to see you. Good to talk to you. Take care.
Bye.
Take care.